I brought up a concern about our legal strategy to my attorney. The attorney asked, if you don't trust my judgment, then why did you hire me?
That's a red flag to me. I think that the lawyers do this type of work all day, every day. We can be a little insensitive to some of the issues and the stress that a client might be going through. So it's important to keep that in mind. I mean, they're the ones who are facing the charges. They're the ones who are facing the potential consequences of a conviction. It's a very stressful thing. So instead of getting offended by a question, I think more conversation should occur. I, for example, would say, here's why we're going to do what we're going to do. Or I understand your question. Let me explain it to you. Here's what I'm looking at. Here's what I'm thinking. And I guess taking the time to iron out that question, explain that question, explain the answer the best that you can. An attorney shouldn't jump to being defensive and making a comment like that.
I called my attorney at 1 p.m. with a question about our court date the next day. I didn't get a call back till 10 p.m.
I think that's actually a green flag. I don't think that is actually a red flag. On the one hand, you're thinking that is, oh my gosh, my attorney didn't get back to me at 10 till 10 o'clock. On the other hand, to me, that shows that they actually really care. They didn't throw in the towel for the day. They didn't go to bed and not catch up their calls. That's somebody who said, I need to get back to this person today. A few-hour turnaround is actually pretty good for most attorneys. I think we should strive to get back to people as quickly as we can, take calls as they come in if we're able to, but a same-day response is actually for the field very good. Getting back to somebody that night at 10 o'clock shows me that they actually care.
My attorney is using a legal strategy that they don't use often, but believe will get me the best result.
I think that's probably okay. I'm trying to think quickly about what type of strategies those might be, but our job is very strategic and every case is different. And yes, there's going to be a lot of repeat defenses and strategies in cases, but if there is a unique case, a unique strategy might be the correct way to go. What I would do personally is I usually would have a meeting with a client of mine and I would say, kind of, here's our options. We can go this path, this path, this path. The path that I'm planning to pursue is this. Here's why. Here's why I think it's a good way to go in this case. Here's what I'm going to try to do and why I'm going to try to do it and why I think it's a good approach or our best approach. So I don't think there's necessarily something wrong with taking a unique approach in a case, but I try to let a client know kind of where we're heading and what could go well, what could go poorly, and be ready to pivot also. So sometimes we're on one strategy and we say, oh, we better go on. This is the new strategy. So it's hard to predict where things are going to go, but doing something unique is actually pretty regular.
My case has a rare and odd circumstance that came up in court. I asked what that meant, and my attorney said, I don't know, I'll have to investigate it.
I think it's a red flag because of the shortness of the response. No matter how long you've been practicing, there are going to be issues that come up that need research. There are going to be issues that come up that are not necessarily black and white answers. So are we going to do legal research? Yes. Are we going to need to figure some things out? Yes. So I think a more thorough explanation rather than a one-sentence response of, I'll look into it. I think the background of why it is a tough issue or why it is a unique issue or why it toes the line of it would be clear if it was more like this or it would be clear if it's more like this. But where we've found ourselves is somewhere in the middle. So this is a unique situation. I'm going to dig into this some more to try to find out what side of the line we're on. Because, I mean, you don't want to just guess. And you're going to need to provide examples in some of those situations. So I don't think it would be a red flag if it were explained better that, yeah, this is a tricky issue. Here's why. Here's what I mean by that. And I'm going to go figure this out.
My attorney seems to do the paperwork on time, even if it's really close to the deadline.
That goes both ways. making a deadline is making a deadline. Many of these deadlines can be extended. So if it were dangerous to put that motion in at the deadline, what most people would do is reach out to the court and say, can I have another week? Can I have 2 more weeks? That's usually granted. Not always, but yeah, I don't think a attorney should be scrambling right before to start and finish their work if it's a difficult case. Working on it and working on it and working on it and submitting it at the last minute, I think, is appropriate. I don't think much advantage to submitting it a week early. So on time is good. I guess the bigger question is, how good is the motion in general, and was the proper amount of time given to it? So whether the proper amount of time is a week ahead or the proper amount of time is the day of, as long as the proper amount of time was given and it's done well, I wouldn't be concerned about just meeting the deadline.
I just received a bill from my attorney and am confused about some of the charges. When I asked about them, they said, just some court stuff.
It's a red flag to me. We've talked about it. Lawyers are expensive. If there's attorneys that are working on an hourly basis, that might be $300 or $400 per hour. So I think it is a fair question to ask, what does this bill mean? I think that's too short of a response. I would expect something more like, we had to file a motion. The research for the motion took time. Filing the motion took time. We had to do this conference. That took time. We had to do a phone call. That took time. I had to send emails. It should be more than just court stuff.
So what if you are within, like, you've already hired your attorney and you decided later, you're like, I don't think this is going to work out very well. Is there a process that people can do to hire a new attorney and get a new form of counsel, even
Yes.
if it is going to trial?
Yeah, so if you're in the middle of your case or the beginning of your case, at any point during the time, you have the right to switch. So it is fair game for you to call another attorney, tell them what's going on, and basically interview them. And if you feel like they would do a better job or you would be more comfortable working with them, you can hire that attorney. The attorney that you hired will let the other lawyer know that they're taking over, that they've been hired to replace. They will let the court know that you're there taking over and that they've been hired to replace. So yeah, if a situation is bad, don't stay in it. Honestly, usually the quicker that you switch, kind of the better. There are certain points in a case that are kind of hard to go back on. So for example, if a case has already had motions and hearings and then you hire a lawyer, it's hard to get back in front of motions and hearings. Sometimes we get calls from people that they say, trial's next week. That's too late. So if it's a bad attorney-client relationship and you're certain it's not a good fit or you're not sure if it's a good fit, call another attorney and you have the right to switch.
So if you do switch attorneys, is there any financial obligation to the first attorney?
So the financial obligation of the first attorney is usually going to come down to what was in your retainer agreement. So when you hire a lawyer, they should put together a document that outlines the scope of the representation. So it's going to say basically what they're going to represent you on, and it'll talk about the financial piece, how much it's going to cost. There should be a paragraph about what happens if there's a breakup. So if you get fired, what happens with the retainer, depending on that agreement. Basically, these retainers are kind of like contracts. So if there was an agreement, then the agreement should be honored. So if a lot of work has not been done, there usually should be some form of a refund, but it will be agreement specific.